he was provided with orders that indicated he was to abide by conditions that included staying away from where Governor Sununu would be and or coming within close contact with him. And it's my understanding that in response to that, he indicated he was not going to abide by that order, expressed that to the court, and later on went to the State House and was in close proximity to him in violation of that order. The state is not asking at this point that he be incarcerated.
You can't.
For that conduct. Our position is simply that he be re-admonished with respect to those conditions, and that he understands he is not allowed to just freely violate those orders and conditions of bail. I would indicate to the court, it's my understanding, that he made statements to these effects when he was in court and arraigned on those charges as well, indicating to the court that he did not intend to abide by conditions of bail with respect to limitations on his ability to go to public facilities and being around the governor.
Okay. And as I understand it, the bail orders were modified at some point in time in December, is that correct?
Yes, Your Honor.
Would you like to be heard on the motion at all?
Yes.
Just briefly, if I may, as the court identified, the conditions had been modified in December. We had filed written constitutional objections, and as a result, the government didn't file a response relative to those. As a result of that, this court had reduced the distance from, I believe, 1,000 feet to 100 feet or 20 feet while participating in the public process, essentially. So I would suggest, as amended, Mr. Staples wouldn't necessarily be in violation of those conditions, and I would ask the court to take no action relative to the motion.
And I would like to say that the only thing they're trying to keep me from participating in the political process, and they are trying to use these bail conditions as a restraining order without going through the evidentiary process to improve the need for a restraining order. So it's telling me I can't go to the State House and I can't go to within 1,000 feet, that means I can't go on the State House grounds at all. And I'm pretty sure that they objected to changing my bail conditions only. They agreed to everyone else's bail conditions going, but not mine. I don't know, I haven't seen the order of what that last judge did, but
that modification applies to you.
okay, well, either way,
It does.
I am not going to be scared to go participate in the political process. It's not going to happen. All I've been dealing with, please let me speak, don't touch me. I have been harassed and intimidated for trying to participate in the political process and voice my grievances. I've been arrested for a loud voice. I was arrested for making a loud noise, allegedly, when I didn't make a single noise. Okay? Other people are arrested for saying amen. I was here for arraignment, and there was no prosecution. I have filed a motion today to dismiss this case for failure to prosecute. Okay? This whole New Hampshire 9 thing needs to get thrown out. You can't be intimidating us for attending a meeting and singing the Pledge of Allegiance forcefully or aggressively or enthusiastically and cheering over the Pledge of Allegiance. So we can't be patriotic Americans? Are you kidding me? This is about the Constitution and our constitutional rights. Okay? So no, I'm not going to abide by any bail conditions that are actually a restraining order that has not been gone through the process. If they think they can get me on a restraining order, take me to court and get the damn restraining order. But bail conditions can't be used to intimidate people like it has been. Not going to happen.
Your Honor, I think that a little clarification may be in order here. And correct me if I'm wrong, but the modification in the bail conditions that the prior judge has ordered was in response to the objections that Mr. Staples is making today, and was an attempt to accommodate his and others' strong desire to continue to participate peaceably in the political process. And I think that Mr. Staples is beginning to understand that that modification was done with these considerations in mind. And as a practical matter, I think that the modified bail conditions are not gonna be hard for him or anyone else to abide by. Note our objection to them. We felt that there should be none. But be that as it may, as a practical matter, in terms of compliance moving forward, I don't think any of us have a concern that we're gonna be in front of you again on a motion like this.
May I ask who you are, sir?
My name is Attorney William Gens, and I'm co-counsel. I work for the same firm that Mr. Stanton does. He's admitted in New Hampshire. I'm admitted pro hoc vice, but in full candor, only for Miss Therese Grinnell, who's one of the defendants here. But I'm very familiar with Mr. Staples' matter, and so I thought as an aid to the court, I might try to assist in clarifying just what we're talking about.
That was very helpful, thank you. And I will say that I read the order that Judge Staff issued, and if you can't hear me, I'm sorry, I'll try to speak up. I read the modification to the bail order that was issued by Judge Staff to be, as you say, to try to accommodate some of the concerns that are in hearing and to allow the parties to move forward in this matter and noting their objections, and I think that's the crafting of this bail order. Okay. So at this point in time, sir, is it my understanding that you do not have a copy of the new bail order that issued?
No, I don't have a copy of it. And I thought that this bail revocation was because of the arrest at the fiscal committee meeting.
So what I am being told, and correct me counsel if I'm wrong, is that there was a motion to revoke bail, however, they are not asking that your bail be revoked today.
It can't be.
Okay,
So this is what I'm trying to get at, is this is the second or third time I've been brought in on bail revocation hearings for being arrested for disorderly conduct because I'm participating in the political process, and I'm getting arrested twice for it because of these bail conditions. So the bail conditions are a no-go for me. I object 100% to any unnecessary bail conditions, and there is no reason. I want to know your findings of facts and rulings of law and your rationale for putting any bail conditions whatsoever.
so the bail conditions were put in place in December. They stand. They have been modified. So the bail conditions I'm referring to are the modified bail conditions
Sure.
as of December 28th, which was, from what I understand, after the date of the offense that was the basis for the motion for bail revocation.
Whatever.
However, today there's no request to revoke the bail. So
I'm requesting for the bail conditions to be lifted.
Okay.
And I'm
denying that request.
okay, well, I just want it on the record.
It is on the record. It's noted in your.
Excellent.
objection is-
That's fine, and I keep violating them and doing whatever I got to do. You guys want to keep arresting me for bullshit? Let's do it.
Okay. I'm gonna request that if you could not.
Is that a law?
It is a.
And I am going to request, hold on, ADA, reasonable ADA accommodations. I have post-traumatic stress disorder, and I have post-concussion syndrome, and I suffer from hyperaggression. So when I get amped up, there's no turning me down. It don't matter what you say, what you do. If a swear slips out, a swear slips out, okay? I'm not doing it intentionally. It is what it is. You're not going to control my speech.
Is there anything that we can do to accommodate you, sir?
Yeah, let it go. If I swear or if I'm loud like I am right now, I get amped up, just accept it for what it is and don't get intimidated or get your feelings hurt because I'm loud and aggressive. It's just something I can't control. That's like saying somebody with Tourette's was in here going, whoop, whoop, and then you're telling me, you can't do that. You can't tell me that I can't have my disability, okay? So it's well known that I have prolonged post-concussion syndrome from head trauma. Well known.
Your Honor, if I may just summarize where we are so that we can proceed to other matters. We've provided Mr. Staples with a copy of the modified bail conditions. He's objected for the record. I know the court has duly noted his objection, denied his oral motion, but I will advise him that if he should want to reduce it to writing, that it's certainly, it's always without prejudice, and it may come up for discussion on another day. I would, with regard to the bail, the bail order, there is an issue of clarification that I would like to take up just briefly with the court. on behalf of Ms. Grinnell and essentially everyone else, the last paragraph of it makes a reference to gesturing. And my interpretation of it would be threatening gestures. But it doesn't say that. And the way it's written, it could be something like raising your hand at
Anything could be a gesture.
at a hearing. Some gestures indeed would be troubling, a throat slashing gesture, giving the finger, other type of things. So if the court might consider modifying that to a threatening gesture, I think it would provide good guidance for everyone here who's a defendant or a participant in these types of political proceedings to ensure that there's no misunderstandings and to avoid many future hearings like this, either for Mr. Staples or for anyone
I
else.
agree with that. It's definitely a problem because,
Well,
and this is the thing,
she-
well,
she
hold
listened to me.
on. And I agree, you're 100% right, but threatening is already a crime. So if somebody is threatening and, like, it's already a crime, why does it need to be put into the bail conditions to make us feel like, I can't even go, I don't know, what if I show up to one of these hearings and, they say that I, this was a gesture. I did a gesture. I mean, come on.
Well, you raise a good point, but that's partially for your written motion to reconsider.
Thank you.
I'm just looking for clarification on that sole point.
I just want to know, does the state have any objection to modifying it to include threatening?
Yes. No objection to that.
Okay.
Oh.
The one thing that I would just make clear is, I take the reading of this, and again, I'm not the judge who wrote it, but I would add to that it is disruptive to the process. High-fiving because of the noise is disruptive. So just so everybody is clear, that I am modifying it to include threatening or any other gesture that is disruptive. So
It's so
if
vague,
it
though.
makes noise.
You're creating a law.
No.
I'm clarifying.
No, you're creating a law.
Let her finish, let her finish.
Noise, I consider it disruptive, okay? Is this a bad gesture?
Yeah. Is this a bad gesture? Because this is one of the gestures that we made that we're in trouble for.
This disruptive communication,
I'm not gonna go through every possible gesture.
Well, that's the point.
Okay, well, look, it's gonna be better than it was before. Don't let the perfect be the enemy of the good.
Gestures.
Okay.
Intimidation tactics is what it is. It's not going to work. It ends here, now, today. Whether you like it or not, Judge. I know we're going to have an... I can't wait for this to go to trial. I'm going to embarrass the state. This guy, I mean, dude, seriously, where were you the last time?
Okay.
Where were you this morning?
Frank, let's move on to other matters.
Why weren't you here this morning, and why weren't you here at the first arraignment? This case needs to be thrown out for failure to prosecute.
Too soon.
What if we didn't show up twice?
So now, the next thing I have before me is the motion for the bill of particulars. Is there an objection from the state for the bill of particulars?
Of course there is.
What I would indicate to council is that it is our position that the charges are give adequate notice, specifically under the disorderly conduct charge 644-2, Roman 3, subsection A. That is the particular aspect of the statute that the state is proceeding under. To the extent the complaints for disorderly alleged conduct.
What section again was that?
Is more specific in terms of the designation. I would ask the court
He said the subsection.
to at least either modify the complaints or at least as was create a record that the state is intending to proceed under Roman 3, subsection A, namely making loud or unreasonable noises in a public place, making loud or unreasonable noises in a private place which is referred to a public place or other places which noises would disturb a person's average sensibilities.
If they don't have a legitimate purpose, you forgot about that part.
And specifically, the statute also makes it a misdemeanor if the offense continues after a request to desist.
Entrapment. The whole thing was entrapment. Obvious.
So I don't
Judge, what I would ask, as we had asked in each of the written motions, and everybody's is a little bit different, but they're all confined to the disorderly conduct charges. I've reviewed the charging documents in detail, and I would suggest that it's short relative to proper notice, due process, and the like under the U.S. Constitution as well as the New Hampshire Constitution, to put these individuals on notice as to what conduct is in fact alleged, for which portion of the statute is alleged to have been violated. And most of this conduct, as we had articulated in the written motions, is post-arrest conduct. So it appears from my review of this is these individuals were taken into custody, many of them, arrested, and made some sort of exclamation in protest to that arrest. And that is backfilling what is being used for the arrest. And that's in many of them, not all, but many of them. Some, for example, relative to the conduct, and I'm sure Attorney Gens can elaborate, Therese Grinnell, the exclamation was amen. So the court knows where I'm going with that. That's a clear expression of religious statement in a clear violation of the First Amendment. I would suggest that's protected speech any way you look at it. And the others are like and similar. I would largely rely on what I had reduced to writing, but I think for clarity's sake, I would ask the court to enter an order for the government to put into writing what conduct is alleged as to which portion of the statute, so we're not looking at a moving target, because otherwise that's what it is. It's a moving target, and our Constitution is clear relative to that. We need notice as to what we're being charged with, so as we can adequately, properly prepare and defend ourselves going forward.
So are you alleging, so I am following, of the 10 or 9 that I have, your statement is that some of the conduct that's alleged in the complaint was post-arrest?
Some of it is, in some of them, yes.
Can you identify for me which ones were post-arrest? Just so I
Mine,
can-
for sure.
Mr. Staples
Well,
is an example.
Let me address her. Your Honor, I'm going to address you regarding Ms. Grinnell, but because of the way the police report is structured, it inevitably involves Mr. Staples as well. And I'll just read you 4 lines from it.
All of them, just so I can see the complaint. So which one are you looking at right now?
I'm looking at, this was, we only got this recently in discovery. It's a narrative police report of what occurred that day.
So are you speaking with one of the
And it's the
59.
on page 59 of the discovery that was served on us. I don't know that the court has it, but I'll gladly hand it up to you.
One of the defendants specifically?
Yes,
Which one?
Ms. Grinnell, but it also includes about Mr. Staples too.
Okay, I just want to have the complaint in front of me so I can follow what you're saying.
Absolutely.
Okay, go ahead.
Okay. I'll just read to you from the narrative. At approximately 11:14 a.m., Sergeant Vincent Greco and Sergeant Greg DeLuca approached Grinnell and Staples. Sergeant Greco tapped Grinnell on the shoulder and asked them to follow. Grinnell and Staples followed. Sergeant Greco and Sergeant DeLuca to the back of the room and behind the solid partition curtain that divided it up from the meeting. At approximately 11:15, Staples yelled, "Shut it down," from behind the curtain, and Grinnell yelled, "We're being arrested." And that is all that lines up with the statement that charged Ms. Grinnell with disorderly. We're being arrested. It's clearly they're in custody. They're behind a curtain. They're separated from the room. If that's the basis of the the state's charge, then we need, in a bill of particulars, they can simply say it. In other words, your people were taken into custody, they were arrested, and they made statements that we consider to be disorderly conduct. If it's something prior to the arrest, we need to know that. But there's nothing in any of this voluminous discovery that we've gotten, and we don't believe there's nothing that exists that gives rise to any cognizable charge of disorderly conduct prior to that. Obviously, we would need to gear our defense to what the government's actual pleading, what their actual allegation is. It's not discovery. It's notice and due process for us to prepare our defense properly. And the state just it's not burdensome, just needs to choose. Is it going to be post-arrest conduct or a conduct undisclosed prior to the arrest?
And exactly what am I being charged with? So you look at my thing, it says and or. I'm being charged with this and or this and or this. Well, what is it? And or or. What am I being charged with?
Okay, I think she understands.
Would the state like to respond, is there an objection to identifying pre-arrest, post-arrest?
No, Your Honor, what I would indicate is, I think that the defense is now making a statement as to there was an arrest, and what I guess I would submit to the court is, I think that is an open factual question. I don't necessarily agree with that. I think that the fact that the police had become aware that there was some disruption, and a couple of the state police officers went over and identified Mr. Staples and Ms. Grinnell, and said, we want to, take you back and perhaps discuss this further, maybe get you to quiet down so we don't have to arrest you. And then
No, that's not
the two of them, there were outbursts, and as it's alleged in this report.
Lie. I was in cuffs.
Let him speak.
Well, he's acting like he was there and he wasn't even there. He's speculating.
We'll get to
It's
respond.
very hard for me to follow the conversation if everybody talks at the
Sorry.
Go ahead.
So what is alleged to have occurred within a minute of them asking, we'd like you to come back here and talk to us a little bit about this, is a response by Mr. Staples, shut it down, just sort of consistent with what he said.
After I was in cuffs, guy. So stop lying. That's why we need a bill of particulars, because you're making shit up.
Sir, I can't hear him if you're speaking, so.
That's the point of me
That's
speaking.
your ability. I can't conclude the hearing or move forward if I can't hear what's being said. Thank you.
We'll get out.
And then Ms. Grinnell is alleged to have yelled out, we are being arrested. And then Mr. Staples again repeating, we are being arrested, fuck this shit. That's what is alleged to have occurred.
So we're
That is
before we were arrested, we were
before
saying we were being
there was
arrested.
a formal arrest, and these outbursts that are occurring after there had been a admonition as a result of the collection of people being there, being told, look, we can't have outbursts here, this has to
Entrapment.
over the meeting of the government, and, people need to abide by certain rules, and then once the process is started, there's more disruptions, there's an attempt to try to quell it, and then in response, the allegation is prior to a formal arrest, there is an outburst by Mr. Staples, now there is an outburst by Ms. Grinnell, and it's our position that those things are being done in a manner which is deliberate to disrupt, making loud and unreasonable noises to disrupt this meeting.
So, am I hearing correctly that the state's position is for all of the complaints, that the allegations contained in the complaints occurred prior to arrest?
That's right.
Does that address?
That's completely bullshit.
Well, it addresses it somewhat. It'd be nice to have it reduced to writing, because these things are typically read to the fact finder.
You did not have an objection to reducing that to writing?
I have no objection to.
Okay.
Then the
Yeah.
other issue is this. In many of the complaints, it talks about disrupting a hearing, a public hearing. The part of the reason I read what I read to you, and the part that intrigues me, is that they go behind a solid partition curtain. Okay? They're no longer in the meeting room.
Right.
Or part of the meeting, and nothing here even alleges that this is disrupting a public proceeding. So, what we're looking for is some sort of particularization of how these statements, in a separate place, behind a solid partition, are disrupting the hearing. And that is just open to speculation.
When we were
Are they
already arrested.
Are they claiming that the hearing was continuing, it wasn't paused? B, the people in the hearing could actually hear them through the solid partition, and C, that it was disrupting the hearing? If they want to put that, it's very simple to put that in writing, because our defense will be structured on that too. There are literally hundreds of people who are present who could testify that they didn't hear a thing.
do you have any objection to that portion?
I don't, but I would indicate to the court that I was doing orally, but I could do it in writing. I may ask the court to take a view, such that the court will have the familiarity. My understanding is that the physical nature of where the meeting was being conducted, that when they went behind this curtain area, it did not in any way reduce the ability for the noises to be heard in the area where the meeting was being conducted. That's my understanding. And I would ask that there be a view, that the court take a view.
So if somebody wants to file something about a view, we can address it. It sounds like this is an element that may be part of the case at the end. If you're asking for location of where the person was when the comment was made, is that what you're asking?
No, when was the arrest? No, hold on, because when we were told to come behind the curtain is when the arrest